I thank you very much for your testimony, and I'll begin the questioning and recognize myself for 5 minutes. Chair Khan, welcome back. As you know, the third branch of government spoke once again on how government agencies should be conducting their work. On June 28th, the Supreme Court, as you know, in its decision on Loper Bright Enterprises versus Raimondo, overruled the 1984 decision in Chevron versus Natural Resources Defense Council and a 6-3 majority. This will certainly impact the FTC's authority and how it enforces its regulations currently on the books and how it issues new rules. Can you explain how this will now frame your work going forward, please?
Thanks, Congressman. So at the FTC, we've been following closely a lot of the developments across the courts, including at the Supreme Court, where, as you just noted, there have been a set of opinions recently that deeply implicate administrative agencies. And so we've been digesting those opinions and making sure that across the board, our work closely hews to what those rulings say. I'll say a general matter, a core pillar of my approach to the FTC is making sure that we are being faithful to the text of the laws that Congress has written and making sure that we are honoring all of the provisions and not, as unelected bureaucrats, by de facto nullifying authorities or tools that Congress has given us. And so that's really informed my approach to the FTC's enforcement work, and will continue to do that in adherence with all court rulings.
Thank you. Commissioner Slaughter, same question. Can you discuss how this is going to impact how you review rulemakings going forward, please?
Thank you, Mr. Chair. I will associate myself with the chair's remarks. I agree that there's a lot of opinions to digest. We always have to make sure we are faithfully following not only the statutory text, but the court interpretations of those texts. And we will look at them closely and understand how we'll proceed. I will note that as a general matter, much of the rulemaking that we've done at the FTC for decades, since the 1970s, has not been general APA rulemaking. It has been under the specific framework in the Magnuson-Moss Act, which provides both structural guardrails on how we do rulemaking in terms of additional procedural steps, and also substantive guardrails that are really important for us to follow. We cannot, by rule, prescribe or prohibit conduct that would not be prohibited by the FTC Act at all. In fact, by rule, we can only address conduct that is already an unfair or deceptive act or practice and is prevalent in the economy. So those guardrails are really important, and we will continue to apply them faithfully, consistent with Supreme Court precedent.
Okay, Commissioner Ferguson, same question. Thank you very much. Appreciate it, Commissioner. Commissioner Ferguson, you're recognized.
Thank you, Mr. Chairman. I think it's going to discipline agency process across the board. Commissioner Slaughter's right that a lot of our rulemakings are governed by a different statute than the APA, but I think since 1984, and especially over the last 20 years, agencies have relied on Chevron to get away with a lot of stuff that I think they would have a hard time defending if they just had the text of the statute to rely on and couldn't rely on judicial deference. That has come to an end. I think that Loper Bright is going to sort of discipline internal agency behavior as they come up with their rules, and if it doesn't, the courts of appeals will.
Thank you very much. Commissioner Bedoya, you're recognized. Same question, please.
Yes, sir, Mr. Chairman. I'll add to the chorus you're hearing here. Of course, we have to take into account these decisions, and if it's a different level of deference, obviously our staff and we have to take that into account. At the same time, as my colleagues have said, I'll say that the court didn't overrule our authorities under Mag-Moss, say, to issue rules and our mandate to identify prevalent unfair trade practices and make sure the American people are protected from them. And so that process has guardrails. We have to follow them, and that, I think, is what you will see us doing.
Thank you very much. Commissioner Holyoak, again, can you discuss how this is going to impact how you review rulemaking going forward, please?
Yes, thank you. As Commissioner Ferguson said, I think it will discipline the agencies. As I review Loper, I particularly paid attention to something that Justice Gorsuch was talking about in terms of what is required. We need to be as be looking at statutory text, linguistic context, and the canons of statutory interpretation, and that will be our burden. We have to be prepared to go to court and defend what we are doing, going back to the statute and looking at those, and not just a permissible interpretation of a statute, but the right interpretation. And that's what we will have to do. And I have done that just recently in one of my dissents in the health breach notification rule, relied on statutory canons of interpretation when I showed that the rule was overbroad in with respect to the specific statute at issue.
Thank you very much. I appreciate that. I'd like to remind all the commissioners how important the Consumer Protection Mission is on fraud and deceptive practices, and it is inviting to debate. Again, we talk about the antitrust theory. The single most important thing to me is how consumers are getting ripped off, and they are getting ripped off and scammed by bad actors, especially, I'm concerned about our seniors. I ask you not to lose sight of that. None of you, please don't lose sight of that. It should be a priority. Not divert resources under the assumption that it is best left to state attorneys generals. And I have to yield back because I want to be fair to my ranking member. So I yield back and I recognize the ranking member.